St. Louis, Missouri, and this is your Elder Law Minute. Question: if a person who is in a nursing home on Medicaid receives an inheritance from somebody else who dies, is that going to affect their eligibility? Quick answer: depends on how they receive it. The wrong way is the most common way, and that is if they are provided for outright in the will or the living trust of the person who has died. In that case, if they receive the inheritance, then they're going to be over the Medicaid asset limit, and they're going to go off Medicaid until they have spent down that money paying for their nursing home care. But if it's done correctly through something called a special needs trust or a supplemental needs trust, then money can be set aside for the benefit of that person who is in the nursing home to pay for things that Medicaid doesn't pay for. And when that person in the nursing home dies, that money is still going to stay in the family. So, big lesson there for people who are planning their estates. The biggest example of that is a married couple, because if the spouse who's not in the nursing home dies first, that can be a big problem. One advantage on that is if the planning has been done through a living trust rather than a will. In that situation, even if the person hasn't been provided for through a special needs trust, if we have a living trust, there are legally available procedures where we can convert the provision for that person in the nursing home in the living trust into a special needs trust. So, lesson here: if you have a family member who is older and either is in a nursing home, or that might be the case before you die, see a lawyer, because the way in which that planning is done is going to make a huge difference. Thanks.